All right, great. Well, good afternoon, everyone. Thank you for logging in today on a Friday before a holiday to learn more about the evictions process in Maryland. My name is Chelsea Heyman. I am with the Maryland Department of Disabilities. I am the Housing Policy and Programs Director for the department. And today we have Kane Levings, who is an attorney with Disability Rights Maryland, who will be presenting on this topic. We have offered this training in the past. It's wildly popular. We had over 300 people registered for this webinar, which is telling to me about hopefully trying to get the information out regarding the evictions process, what is allowable and not allowable. But also, sadly, it seems like this is a in-demand topic because I believe the trend of evictions is just going up and up. So we're happy to provide the information, and hopefully Kane will be here to answer any questions that you all have. Just some logistics I wanted to make mention of. There is a chat and there's also a Q&A. For those of you who have questions, I'd like for us to, ensure that we're putting those in the Q&A and not the chat. If it's related to the presentation, if it's more of a logistical question related to how to use Zoom or technical difficulties, please put that in the chat so I can go ahead and address those. As you can see, there's people including their name and their organizations in the chat, which is great. And yeah, I think that that's about all I have. And yes, I've seen a few people asking about sharing the PowerPoint. We can do that as well after the presentation. Okay, so I will go ahead and let Kane take it away from here.
Thank you, Chelsea.
Okay.
As Chelsea said, my name is Kane Levings. I'm a staff attorney on the Housing and Community Inclusion team with Disability Rights Maryland. My job day to day focuses mostly on evictions. So this PowerPoint will be going through the Maryland eviction process, the types of evictions, the most common types of evictions, what landlords need to do, what tenants need to do, where there are some avenues related to disability, and hopefully this information is helpful for you when you work with your clients. Next, well, you can skip to the third slide. Okay, so here is a list of the 3 most common types of eviction. So if the tenant allegedly breached the lease, if the lease is ending and the landlord has decided not to continue renting to the tenant, this is called a tenant holding over case. And then if the tenant hasn't paid rent, or called a non-payment of rent or failure to pay rent case. Next slide, please. So depending on the type of eviction, there are different rules that a landlord has to follow. There are different defenses to different cases. So we can go on to the next slide. So this is a very brief overview of the court process for a legal eviction. So first, for all 3 of the eviction types I just listed, there needs to be some form of written notice explaining why the landlord is evicting. So if it's for failure to pay rent, the landlord has to give a 10-day notice prior to filing. If it's a breach of lease, it is either 30 days or 14 days. And for a tenant holding over, it depends on the term of the lease. And I will get into the specifics on later slides. So a landlord, after the notice period has ended, the landlord can file a complaint in district court. A landlord is not allowed to file if the notice period was 30 days. They can't file on the 29th day. If they do, then that would be cause to get the case dismissed. Then let's say the landlord exhausts the notice period and files the complaint in court. The tenant will receive a summons and complaint, which explains the reason for the eviction and lists the trial date. So the landlord has to appear at trial. If they don't, the case will be automatically dismissed. And the tenant needs to go to trial. If the tenant doesn't go to trial and the landlord doesn't voluntarily dismiss the case, then a default judgment would be entered if the tenant did not appear. At this stage is when a tenant can present defenses, but it's important to note that the landlord has the burden of proof in these cases. So the tenant doesn't need to present their defenses prior to the landlord presenting their case and meeting the burden of proof. There are different defenses. For example, in a failure to pay rent case, if the tenant has withheld rent due to poor conditions in the unit, they might have the right to a rent escrow defense. That's a very common one in a failure to pay rent case. Other defenses would be lack of notice, improper notice, things of that nature. So then let's say either the tenant will have the case dismissed, which is essentially what you would want, or the landlord wins the case. After that, depending on the appeal period, which I will get into, the landlord has to file a warrant of restitution, and the judge has to sign off on the warrant of restitution. Once the judge signs off, it automatically goes to the sheriff, and the sheriff is the organization that will schedule the eviction. If the landlord does not file a petition for a warrant of restitution within 60 days of the judgment, then the warrant will be expired and the landlord cannot move forward on that warrant. So then the sheriff is the entity that schedules the eviction, and depending on the type of case, so for failure to pay rent, the tenant has the right of redemption up until the time the sheriff arrives. So if your eviction is scheduled for 9 a.m., the tenant would have the right to pay and tender payment to the landlord up until when the sheriff arrives at 9 o'clock. This only applies if the tenant has, say, cash or a cashier's check. They wouldn't be able to just write a check on the off chance that it bounces to stop an eviction. And the right of redemption is only available if the tenant has not received 3 judgments for non-payment of rent within the past 12 months. So that's something to look at if your client has received a few judgments in the previous 12 months. Next slide. I see there's a question. Do you want me to address questions as I'm going or at the end?
It's kind of up to you.
Okay.
This question was just somebody saying, I didn't understand that you can't file on the 29th day. Thanks.
So I'm not sure if that was a question, but I will reiterate that you cannot file on between the period of the notice. So whatever the notice period is, if it's 10 days or 30 days or 14 days, if the notice starts on, say, July 1st, and it's a 30-day notice period, the landlord cannot file in court until July 31st. If they file earlier than that, then that would be cause for dismissal, because that means that the tenant actually hasn't held over, for example, on a holding over case, because they still have the right to possession of the property on that 29th day.
Someone did ask, Kane, would that be 3 judgments under the same landlord-tenant agreement?
No, that would just be 3 judgments for non-payment of rent. Gotcha. In the past 12 months. So unless someone is bouncing around monthly to multiple landlords, that doesn't really come up. But it's not landlord-tenant relationship specific. It is just judgments entered against that tenant.
Gotcha.
Okay, so jumping to a tenant holding over. This is when a landlord has decided that they are terminating the lease, or another example of it is if the tenant has given notice to the landlord that they will be vacating and not renewing the lease, but they failed to vacate on the day they say they will. So if they say they're going to vacate and the lease ends on June 30th and they're there on then July 1st, then they would technically be holding over. So the landlord has to give written notice that the lease will not be renewed. Notice, the way that notice is given, the first thing you want to look to is the lease. It should spell out exactly what kind of notice needs to be given, and in what manner. So if that's first class mail or posting it at the unit, if they've elected to get electronic notice. And then, so there's state law on the minimum notice you have to give. So for a year-to-year lease, it differs depending on the county, but it's 60 days in Baltimore City and Montgomery County, and then it's 90 days for every other county in Maryland. And then it's month to month, it's 60 days notice for Maryland. So that's important to know. If you have a client and they received a notice and it is less than 60 or 90 days, you'll, perk your ears up and say, I don't think that there's been enough notice given here to claim that the tenant is actually holding over. Because if the notice isn't accurate and doesn't give the tenant the allotted amount of time that they need for the statute, then the tenant is not holding over and they could not file a complaint. But let's say they did get proper notice and the tenant remains in the property after the expiration. So if the notice was, let's say 60 days and the last day of the notice is June 30th, then on July 1st is when the landlord could file a complaint for tenant holding over. In court, again, the landlord has the burden of proof. So they have to present a lease. They have to present the evidence that the lease has expired and or terminated, and that the tenant was given that notice. So they would have to prove also that the tenant received the notice. Next slide, please. Sorry, there's some questions. I'll try to address them.
Okay, just to kind of go through some of these briefly. Kayla asks, what if the landlord puts 30 days for year to year? Would it still be 90 days in, say, Charles County?
Right. So let's say in the lease, it says that the termination only requires 30 days and it's a year-to-year lease. That violates Maryland law, so it has to be 90 days. So even if the lease says that, but it's less than what the law says, the law governs. So in Charles County, it would need to be a 90-day notice minimum for a year-to-year lease. And so I see Tammy's question, is a 90-day notice specifically for tenant holdover and not failure to pay rent? Correct. So failure to pay rent requires only a 10-day notice, which I will get into after responding to these questions, but it's only a 10-day notice. So on the 11th day, the landlord can file if the tenant hasn't cured, but I'll get into that.
Great.
Do landlords have to say why they do not wish to renew a lease aside from a breach of lease or failure to pay rent? No. So there is no good cause requirement in Maryland yet. So a landlord can terminate a lease without giving reason. They would just have to give notice, say your lease expires on this date. We're not renewing it, so you have to vacate on this date. And then the enforcement mechanism, if a landlord violates the law, well, that would be hopefully the tenant has an attorney or the tenant knows their own rights and can try to present their defenses in court. But unfortunately, if the tenant is unrepresented, which is more likely than not, it is very possible for the landlord to have violated the law and still get a judgment. That's unfortunately the truth. So the difference between a tenant holding over and a failure to pay rent, they're very different. Failure to pay rent is the landlord is saying that the tenant has not paid rent that is due. So if June rent was due, it's certainly late by June 30th, and they're saying you owe us $500 for rent this month. It doesn't have to be the full amount of rent. You know, if the rent is $1,000 and the tenant only paid $500, they could go to court for the remaining $500, of course, given the correct notice. And a tenant holding over is essentially saying that the lease has expired or been terminated for no particular reason, and the tenant has failed to vacate on the date of the lease termination. So it's not a matter of if the tenant paid rent or didn't pay rent. Though one thing we saw during the COVID-19 pandemic, when failure to pay rent cases were paused, landlords were going in with tenant holding over actions because those were allowed during the eviction moratorium. But it's unfortunately an easy way for landlords to get tenants out without actually having to prove anything other than if they gave notice and they terminated the lease. I'll get into it, but there's rental licensing laws, which is another reason why landlords were pursuing tenant holding over actions instead of failure to pay rent cases, because there are specific defenses and requirements for failure to pay rent, which I will also get into with the new legislation, which will start in October of 2023, but I'll get into that. And then there's a longer question here. So this question is, I have a client who moved from an apartment with their lease ending April 31st. The office of the landlord closed at 5 p.m. The tenant returned their keys the following morning at 11 a.m. when the office opened. They were charged on their security deposit for the day. That's a good question. I think, you know, the person probably had until, say, midnight on April 31st to be on the property. I would look to the termination letter to see exactly when that was. I can circle back with you on that one, but I think it would depend on what does the lease say, what did the lease termination notice say. It's certainly an interesting situation, but I'm not surprised that this property has docked someone on their security deposit for whatever they possibly could. So I'm happy to circle back with you on this question to look over some of those documents. Okay. So now we're on failure to pay rent. So this is the type of eviction case that requires 10-day notice. This notice requirement is fairly recent in Maryland. Before it was implemented, there was no notice requirement. So if the landlord says that a tenant didn't pay rent, they could immediately file in district court. This type of notice is specific to the Maryland State Court form. So a landlord can't draft their own 10-day notice. They have to use the Maryland State Court form, or it's a cause to dismiss the case. Again, they have to wait the notice period to file. So let's say rent is late on the 5th of the month, they send the notice on the 6th, and then they can file on the 17th of the month. So then if the tenant hasn't cured, so the reason for the 10-day notice is to give the tenant notice that they are, one, behind on rent and what amount of rent they are behind, and to give them an opportunity to cure. And by cure, I mean to pay what the rental arrears are. Then if the tenant doesn't cure, then the landlord can file the complaint in court. Same goes as tenant holding over. The court schedules the trial, and then the tenant will get the complaint and summons with the trial date. On the failure to pay rent form are specific things that need to be filled out. So you'll want to look through the court form and verify the information is accurate. This is where I was mentioning rental licensing. So dependent on the county you live in, there may or may not be a rental licensing law. And depending on the county, the law affects a failure to pay rent case differently. So let's say there's a property that does have a rental licensing, or a county that has a rental licensing law, and that property is affected by that law. Baltimore City is essentially any residential dwelling that needs to have a rental license if it's not owner occupied. And a landlord cannot pursue any action, like debt collection action, which is what a failure to pay rent is, on that rent if they are not properly licensed. So on the complaint form, one of the top lines is, what's your rental licensing number? And they have to fill that out. So if we're in Baltimore City and it's empty or blank, you would first want to ask the landlord if they have a rental license and to provide proof of that rental license. Or, I mean, even if you're in court, you can advise your client to say the person didn't fill out this, the plaintiff didn't fill out this rental license line. So this complaint needs to be dismissed because clearly don't have a rental license. Typically, though, a judge might say, well, can you just prove that you have a rental license or not? And then that kind of will, show what happens the rest of that court. But it's really important to look for, like I said, a lot of landlords have moved from failure to pay rent to tenant holding over because it didn't require a rental license. However, starting October 2023, the rental licensing law will apply to breach of lease, tenant holding over, and failure to pay rent, which I will get into more specifically, but that's really important to note and something to look out for. You can look on DHCD's website to verify whether the property is licensed or not. So when you're at court, let's say the property is licensed and there are no issues on the complaint, a tenant, so the landlord has to present their case, which is that they're licensed and that the tenant still owes the amount that the complaint indicates they owe. A landlord can amend the complaint amount if the tenant paid a little, or if they didn't pay and they owe more, they can try to amend the amount. It's kind of judge dependent on how they do that. And this is an opportunity for the tenant to raise defense. So, is the landlord licensed? Did they give them the correct 10-day notice? Did they not file in the notice period? Or if the tenant has a rent escrow defense, that is if there is conditions that are a threat to the life, health, and safety of the occupants. It's a fairly high threshold. But when you're in the failure to pay rent posture and you raise a rent escrow defense, typically what will happen is a judge will combine the cases and schedule a rent escrow case to be heard before they make any judgment on the failure to pay rent action. The reason this matters is if a rent escrow case is open or a rent escrow case is filed and the inspector does note that there are issues that rise to the life, health, and safety of the occupants, it's possible that the rent amount could be changed. So, for example, if the property is like completely uninhabitable, the judge might deem that the rent is zero for the past 3 months, or whatever the notice period was that the tenant gave notice to the landlord. Or it might even just be the judge knocks $100 off on the rent for the past 2 months, or that the landlord wants the judge wants the landlord to fix the conditions within 30 days of the trial date, and then I'll answer that question. And then in order to open that escrow, so let's say, sorry, I'm getting ahead of myself. So the judge wants the landlord to address the issues noted by the inspector within 30 days. So you're at trial, the judge might not do anything. It might keep the rent at what the rental amount is, give 30 days, schedule a new inspection and a new trial date, and see what happens at that point. But I see the question that, does the tenant actually have to put money into escrow? Yes. So the first rent escrow hearing is when the judge will review the inspector's list of potential violations. So if there were violations, then the escrow would be opened. And the tenant has to put the money into escrow within a certain period of time. That also is judge dependent. So one judge might say you need to put it in there by that tomorrow, end of business. One judge might say, okay, we'll give you like 5 days to put the money in escrow. If the tenant fails to fund the escrow with the amount of money that the landlord alleges they owe, then the escrow will be dismissed. So it's kind of sometimes it's a helpful defense, sometimes it's not if the tenant doesn't actually have all that money that the landlord claims is owed. But that is a barrier. So let me look at. Okay, so I think I addressed that question. And so I'm looking at what happens if a court notice is mailed to the wrong place. I would say that the landlord has the burden to mail it to the correct place. If they misspelled it, then that's not the tenant's fault. The issue is whether or not the tenant received the notice. And if they didn't receive the notice and they can point to the fact that it wasn't even sent to the correct address, that's a pretty good defense. So that would be a reason to ask the judge to dismiss the case. There's a link. Maybe that's for the rental licensing.
Yeah, I believe so. I clicked on it. And I can put that in the chat too. So that's helpful to have to look up I assume it's like to look up the properties and see if they actually have licenses or if they're registered, or Baltimore City specifically.
Okay. What if there is a lease for a private landlord without a rental license? Is there an enforceable item due to there being a license, or can it be dismissed? I'm not sure about this question.
Yeah, I'm rereading this.
If you want to try to read the question.
Etta, is there any way that you could like elaborate or kind of reword that? I'm just trying to understand what you're asking. In the meantime, there was a question that came in through the chat as well, from Sequoia. Does the tenant have to officially put money in escrow, or is it okay to have money set aside when there are concerns about poor conditions?
Okay, so I thought I answered your question, but I actually didn't read the whole thing. So the first is, if you go to court and you either affirmatively or defensively are pleading that there's a rent escrow defense, or there's circumstances that rise to a rent escrow case, and the judge opens the escrow or grants it, then the tenant does have to fund the escrow. But it is true that a tenant can withhold rent if they've given notice and their landlord has failed to address the concerns. And then as a defense, if the landlord then files a failure to pay rent case, that they didn't pay their rent because of X, Y, and Z conditions, and you gave them notice on this date and they haven't done anything, then the hope there is that the tenant kept that rent money, so that when the case does get transferred to the rent escrow docket, that if a judge opens the escrow account, that the tenant does have the money to fund the account, and it has to be funded in full. So it's not well, I only have $300, I only want to put that much in. It's what is owed allegedly to the landlord. Does that make sense? I don't know can people talk?
If you want to talk, I can unmute you. I just unmuted Etta, so she can have her question clarified.
Okay, great.
Thank you.
No problem.
Apologies. I'm hard of hearing, and sometimes closed caption doesn't always pull up the right things. So I just want to make sure. I don't know if this was addressed or not. But for example, I have a participant who does a room for rent and has a lease, but the landlord, I'm not sure if it's not even a legal location or not. That's something that would need to be addressed separately, but they took them for failure to pay, but they don't have a rental license. Is that still enforceable? Because of the lack of a lease, because of the lease, but a lack of the rental license and or the legalities of the location.
So
I'm
this,
sorry if that's it's
no, it's, so this is a Baltimore, like this is a Baltimore City.
yeah.
Okay, so then, yeah.
Yeah.
Because I'm more familiar with Baltimore City rental licensing versus like Baltimore County, where they're very different rental licensing rules. But so a landlord should not be taking a tenant to court if they don't have a rental license. Unfortunately, that happens so often, and it requires the tenant pursue legal action against the landlord for them doing that, for them filing a case and alleging that they owe rent when they know that they cannot be collecting rent. So yes, it is possible. There is some case law which states that, but it would require the tenant to pursue legal action. And I don't know that there is much case law on the outcome of that. And that's kind of the unfortunate reality of trying to get a landlord to,
Yeah.
understand what they're doing is against the law and they shouldn't be proceeding. Now, if this was happening monthly and this tenant has gone to court every time and said that the landlord doesn't have a license, then that repetitive filing, you might consider some legal action. But I can't say for certain how that would move forward in the court, because I just haven't seen it personally. But the Maryland Consumer Protection Act would be one place to look for that. But I can also follow up with you if you wanted some more resources on what to do in that situation.
I appreciate that. Conversely, is the participant allowed to file for escrow if the unlicensed landlord is not taking care of the unit?
So that's definitely a tricky question. I think, and I have not experienced this, but I do think in that scenario, if the tenant can also show that the landlord doesn't have a license at the first rent escrow hearing, it is possible that the judge doesn't require that the escrow be funded, but that an escrow can still be opened. So it would be the same as if the if the judge deemed the property to be completely uninhabitable and stating that the rent would be zero until the issues were all addressed. It would be similar to that situation where an escrow would still be open and the case wouldn't be dismissed, but it would be because it's clear that the landlord doesn't actually have the right to rent for the time being or for a certain period of time. If the license expired and the tenancy is still ongoing. But it's important to know that the landlord is owed rent if at any point it was licensed. So if the license expired on May 1st, then that period before where it was licensed, the tenant would owe that money. But after May 1st, if the landlord's license has expired, then technically the tenant wouldn't need to pay rent. I will also note that it's important that there is no legal recourse if the tenant is voluntarily paying the landlord if the landlord's not licensed. It's only if the landlord actually pursues the collection of rent while it's not licensed. So that's an important distinction. So if a tenant finds out that their landlord hasn't been licensed for a year, but the landlord hasn't done anything like taking you to pay rent court or filed any small claims action for rent, then there wouldn't be a cause of action there.
Okay. All right. Thank you very much.
Mm-hmm.
All right, we're going to do one more question so we can just kind of keep things moving along. But Tanya asks, I had a client who put in a 90-day notice and they paid the monthly rent, but their lease ended on the 15th, but they were moving out on the end of the month. Does the landlord have the right to start the month rent after the 15th day without notice? Not sure if I understand this one either. I'm assuming she means prorating the lease. I'm not quite sure.
So it would kind of depend on what the
Okay.
notice said.
She did say it means
Yeah.
she's indicating prorating. Yeah.
I mean, at that point, I mean, I don't know when. So if the person gave 90 days notice and they gave it before the 15th of the month and they are there past the 15th of the expiration date, then they would actually technically be holding over. So the landlord could file, but it would probably depend on what the lease said. So that's always like the first place you want to look to see is, if you remain on the property, then, we'll charge you day to day, or if half the rent, but it really depends on what the lease says. If that was a situation where your lease ended on like the 15th or the 30th, that would be where I would suggest a tenant talk with their landlord about, okay, hey, I want to give you 90 days notice, but I'm not actually going to be leaving, or my new lease doesn't start until the 1st of the next month, but I understand that my lease ends on the 15th of the month, and try to have that open dialogue and see if you can agree on a date to vacate. I think usually being open and honest ahead of time is more helpful than just not saying anything and remaining on the property and like being like, well, I'm going to leave on the 30th, because then you get into issues with the landlord and you don't want cases filed against you in court, because you can see that online. But okay, so I will, we can go to the next slide. Okay, so this is the CARES Act, which was obviously started during COVID, enacted by Congress. So this is another notice requirement that you should be aware of in failure to pay rent cases. So this notice requirement is a 30-day notice requirement. It first took effect July 24th, 2020, and it remains in effect today. Congress has not amended this statute. They haven't rescinded it, so it is in effect today. It requires that certain properties provide 30 days notice for failure to pay rent cases. And it's countrywide, but so in the state of Maryland, for a failure to pay rent case, if the property is covered, then they need to provide 30 days notice prior to filing a failure to pay rent action. This is in addition to the 10-day notice that's required under Maryland law. So let's say the property wants to file for failure to pay rent, they have to give 30 days notice, and then they have to give 10-day notice to the tenant. So just really generally, a covered property is any property that, a covered dwelling is the first step, which is any type of residential tenancy, as long as the property is occupied by the tenant and that the property is a covered property. Covered property is the key here. Covered property is any property that participates in certain federal housing programs or that has a federal backed mortgage loan. And it's one really good way to know if the property is covered is if it's covered under the Violence Against Women Act. So an example would be a Section 8 tenant. So if your client has a Section 8 voucher, then your client, that property, that unit, and that entire property that the landlord owns, if it's a multi-family apartment or it's a 4-unit building, then the entire building would be covered because of that one Section 8 tenant. So you'll want to look at if there's a subsidy, if that subsidy is covered under VAWA, and you want to see if the property did give that 30 days notice or not. I think there's a question.
Yeah, it says, can the notice time frame run concurrently?
Right. So let's say you give 30 days notice when there's almost, it's like 10 days, it's going to be up, then you can give the 10-day notice. The reason it's so important that you have to get both notices is because you have to, or the landlord has to use the 10-day notice, the state, the court form, and they can't just rely on the CARES Act notice. And the court form has specific things in it, and that's why it's important. The CARES Act, there's no form notice. It's the tenant does need to get 30 days. And yeah, so I think that covers that. So we can go to the next slide. Okay, so I may have already covered this, but I'll cover it again because it's really important. We're at the point if a complaint has been filed, tenant and landlord go to court, and the judge enters a judgment for possession for the landlord. The tenant has an appeal period. So in a failure to pay rent, it's 4 days, and in a tenant holding over and a breach of lease, it's 10 days. There might be an appeal bond, which is the judge sets an amount that the tenant has to pay in order to appeal. It could be anywhere from $50 to 3 months of rent. So it really depends on what the judge decides. So then let's say after the appeal period ends, the tenant has not appealed, the landlord will file a petition for warrant of restitution. The judge has to sign off on the warrant of restitution. Nothing can happen unless the judge signs off on it. Then the sheriff receives the warrant of restitution and schedules the eviction. In Baltimore City, for failure to pay rent notices, which I should have verified, or I should have clarified here, it's only for failure to pay rent notices. The landlord has to provide 14 days written notice. Prior to the eviction, that notice has to be given by first-class mail, and then the sheriff will verify that the landlord did give that notice, or if there is no notice required, then the sheriff is there to execute on the warrant of restitution. Again, the sheriff has to be present, so no landlord can evict a tenant without the sheriff being there. That would be an illegal eviction. And I've mentioned this before, but the tenant has the right of redemption in failure to pay rent cases unless it's exempted, which is the 3 judgments. And there's a question. Sorry, that's breach of lease, BROL, and TNHO is tenant holding over. Next slide. Which I kind of already went over this, but Maryland prohibits self-help eviction, which is a non-judicial eviction. So as I said, a landlord cannot evict a tenant for any reason without first having, given notice, filed a case, gone to court, received a judgment, received a signed warrant of restitution, and then the sheriff being there to execute the order. That would include a landlord can't, what's called diminished services. So they can't turn off water or turn off the hot water heater or somehow cut off the electric, lock the doors. They can't do anything to prevent full access to the property unless all that's already happened and the sheriff has come and executed the warrant of restitution. And also it's really important to know that a landlord can't threaten to do any of those things either. That would be an illegal eviction, and that would be illegal action by the landlord to even write a letter saying, I'm going to turn off the heat in the middle of winter on this date because you haven't vacated or because you haven't paid me or whatever it may be that they're alleging that you have or haven't done. Next slide. So I kind of touched on this with the CARES Act, but it's really important to know if you're client has a rental subsidy. Subsidies have certain protections and rules that need to be followed. So by both the tenant and the landlord. So sometimes tenants know that they have a rental subsidy. Sometimes they don't know, or they don't know exactly what their subsidy is. But some things you can ask are, is a portion of your income calculated to what you pay for rent? Are you paying only 30% of your rent? Do you complete annual or biannual recertifications where you present your income documents to either the property manager or to a housing authority? And if the client still doesn't know, you could ask them to look at their lease. If, you know, sometimes a lease will say like that the tenant will pay this amount and the housing authority will pay this amount, or it'll say HUD model lease on the top, and then that can indicate to you that, okay, there's probably a subsidy attached to this. And so if there is a subsidy, you've already identified that, and they're facing eviction, you'll want to figure out what kind of subsidy it is. So is it a project-based voucher, or is it a tenant-based voucher? Is it some other sort of voucher that's not, you know, one of the big housing authority vouchers? And you'll want to see if there's any special rules and regulations that those vouchers need to comply with. And that might require you contacting the program, reviewing the client's file to make sure that everything is correct and there aren't any issues to uncover. So an example here is if a landlord has terminated the lease because they are selling the property or for no reason, and then the tenant, what they need to do is they need to bring the termination notice to, say, the housing authority if they have a tenant-based voucher, and they request a move voucher. And the goal is that the tenant can get the voucher and relocate prior to the termination of the lease. So that's really important, especially as of a tenant-based voucher, because if they don't have another voucher to move, then they're certainly not going to be able to vacate and find other housing and be able to afford it without their voucher moving with them. So that's really something to look at, and you want to make sure that the client is obtaining and maintaining their voucher. They don't lose it in the lease termination and the move process. I see a question. If the tenant is holding over because they have no place to go, how long do they have before they are evicted or forced to leave until once their active lease expires? So that depends mostly on when the landlord decides to file. So if they're holding over on July 1st, the landlord could technically file on July 1st, or they might wait to the 15th or the 20th. They could wait till August 1st. So it really depends on when they start the eviction, the legal eviction process. And then they have to file, and then the court has to schedule it. So is it scheduled, 2 weeks after the filing? Is it scheduled a month after the filing? It kind of depends. And I think it's very county specific. If your county has less eviction cases, they might be able to schedule it faster. And then it depends on how busy the sheriff is, because the sheriff is the one that has to schedule and execute the warrant for the eviction. In Baltimore City, if the landlord files it right after when they can't, like the day after they can file, and the case is scheduled within 30 days, I'm hearing that the Baltimore City Sheriff is executing and scheduling evictions or like within 30 days. But I wouldn't say it's typically less than 25. So there is some time. You don't have to necessarily vacate on the vacate date if you don't have a place to go, but then the tenants open themselves up to potential eviction action in court. So I don't know if Weinberg housing subsidy is considered a VAWA, but you can look at the VAWA regulations. It lists out all of the housing that is covered. And that should answer your question.
They're located in low-income housing tax credit properties, so yes, it should be considered under VAWA.
Yeah, the good thing about VAWA is it covers a lot. So if you are receiving some sort of subsidy, like you definitely want to look to make sure it's covered, but it's likely that it is. And VAWA was amended in this past October, so it actually covers more than what it did when it was first enacted. Okay, so we can go to the next slide. So here's where if you're working with a client and you're like their housing specialist or coordinator, you might be helpful. So it would be like alternatives to litigation. Hopefully the tenant and the landlord have a good relationship where they can communicate and work together. Sometimes that's not the case, and it might be more helpful to have a third party advocating for the client, the tenant, in any negotiations regarding eviction. And I already mentioned this first thing, is there a subsidy? You want to make sure that they maintain it. But if it's for, let's say, a failure to pay rent case, or even if it's for a tenant holding over, but the reason for that is because the tenant hasn't paid rent, then you'll want to see, like, can your client pay a little extra each month to start chipping away at their rental arrears, and see if the landlord would be agreeable to that. And if so, the landlord would hopefully not file or dismiss a current action, so that the tenant could enter into a repayment plan. So that's one thing that's actually really helpful. Another thing is, let's say that the relationship has sort of not been working out. Both the landlord and the tenant want to vacate or want to terminate the lease. Then you'll want to see, okay, can we find an agreeable date that the tenant moves out, so that either no case is filed in court, or if there was a case filed, to hopefully get it dismissed. So, I mean, that could be anywhere from 1 month to 6 months. It's obviously dependent on if the landlord would agree to that. But that is something can always be helpful to see, and try to see, like, will the landlord agree to a certain vacate date if the relationship has just kind of, not been working out and everyone wants to, terminate the relationship. Another thing is, so let's say the tenant breached the lease, you'll want to consider how severe the breach was. Technically, a tenant could have breached the lease by not paying their rent. And so, I might argue that that's not severe if they can rectify that by paying their rent and paying what's currently owed, so that there's actually no damage to the landlord. And you'll want to see, is there an alternative solution? This kind of goes to reasonable accommodation, which I will get to, I think, next. But can there be an agreement between the parties to address the alleged breach? So if the breach was that the tenant had unauthorized occupants in the property that were living there, maybe the alternative solution would be that they prove that these people have vacated, and the tenant signs a memorandum of understanding or signs something that says that they won't have any other unauthorized occupants staying for extended periods of time. I want to be very clear that this is really the landlord has to agree and the tenant has to agree. So it's not, if the landlord doesn't agree, then it's not going to go anywhere. And also, you don't want to try to work out a solution if it's something that the tenant can't agree to. And then I will discuss reasonable accommodation in the next slide, but if the breach was related to the tenant's disability. So an example of that would be the tenant has an emotional support animal due to their disability, and there's a no pet policy, but the tenant failed to make that reasonable accommodation request prior to the lease. And then the landlord says, well, you have a pet, you breached the lease, sends their 30 days notice. A potential reasonable accommodation there, if the property is covered under fair housing, would be that this is an emotional support animal and that no pets policy is not applicable because of that reason. And then you want to kind of maybe try to find out what the underlying issue is that caused the breakdown in the relationship. So like I said, because tenant holding over doesn't require any cause or any reason, it could be something very minor. So if there's something that you can uncover and work through with the landlord and the tenant on that issue, it might be a reason to say, okay, can we like try one more time? Let's see if we can, continue this relationship until the end of the lease, or can we continue the lease on a month-to-month basis, or whatever it may be. I think sometimes negotiating with landlords can be very fruitful. But like I said, it really depends on the tenant and the landlord if that's kind of how they want to move forward. Next slide. Oh, there's a question. Since COVID changed the regulations, if a lease is renewed for the full year, but the tenant wants to leave and doesn't have the amount that is required to break the lease, how can they break the lease without having to pay the full amount? Requires 2 months of rent to break the lease as well as a 60-day notice. There's no breach of lease, merely they want to relocate to a more affordable location. So assuming there's no reasonable accommodation in Edna's question. So if there was a reasonable accommodation need to move, so if some disability related need, that would be a reasonable accommodation to terminate the lease and not have to pay whatever the breaking the lease early charges were. But I don't, but I don't think, you can ask the landlord to terminate the lease and see what they say. But I will say the landlord would have to go to small claims court and file for the early termination of the lease. You don't know how common that is. I have not seen it happen with a client, but that doesn't mean it doesn't happen. And I will say that, so for the security deposit, they can't deduct from the security deposit, something like that. The security deposit is solely for the actual repairs needed to the property that are beyond wear and tear. So they can't just take that money if you've given a security deposit. So that it's something to think about, but I would say that's something you would want to ask and see, okay, what if I vacate in a month or something? But if the client can't pay their rent, then that's a really good thing to tell the landlord if you want to break the lease early, because that's not going to help them if, they refuse to break the lease. Then they're going to pay money and spend time and energy filing a failure to pay rent case, and it's just going to be more work for the landlord in that instance. But that doesn't mean that the landlord won't require payment of the 2 months or whatever it is. So this question is about submitting paperwork for the emotional support animal. Right, so yeah, you do need to have some sort of paperwork for an emotional support animal. It could be a letter from your medical provider indicating that you need an emotional support animal due to your disability. It doesn't need to go into what your disability is or why your disability requires that you need an emotional support animal. It can be very boilerplate. But yeah, so you can't just say, I have an emotional support animal because of my disability. That, if the landlord wants to inquire a little bit more, it's called disability verification. In some instances, that is allowable for a landlord to ask a little bit more than just, why do you have this emotional support animal? So a lot of complexes do have specific paperwork.
Yeah.
It's fine to use that specific paperwork, but you don't have to. So if the medical provider does provide a letter, which essentially encompasses what would be in that specific paperwork, then that should be fine. You'll just want to make sure that the medical provider would have to say that, kind of show there's some sort of nexus between the disability and the need for the accommodation. But yeah, I mean, there's really no need to submit both a letter and disability verification. I don't know that it's the best use of time. Sometimes a medical provider might not mind filling out this form, and if it gets the job done faster, it might be the right avenue. Yeah, that's also not surprising. They make the paperwork go to their lawyer to approve the animal. Yeah, I mean, that's not surprising. So that's kind of why I think sometimes it's not worth energy to push back if they're saying, please fill out this disability verification.
Right.
Like, I know you have a letter from your doctor or your medical provider, because it doesn't have to be a doctor. But we just want this for our records. No, they can't necessarily require it. They would have to review the reasonable accommodation based on the information you gave. And if that's the letter from a medical provider, then that's what they have. But if it just makes the process easier and smoother, it honestly just might be worth everyone's time to have that form filled out. It's also like, if the form is invasive, just cross out what you don't want the medical provider to fill out, or ask them not to fill it out, and only fill out the parts that are actually pertinent or what you're willing to share. So if you don't want to share what your diagnosis is or the symptoms of your diagnosis, if that's asked in the verification, then you don't have to fill that part out. So that's another avenue to take if the client thinks that, or just doesn't want too much of their personal information to be shared with the landlord, which is obviously incredibly understandable. And these verification forms can sometimes be super invasive. Yeah, I believe my coworkers have done some reasonable accommodation trainings.
Yeah, we have as well. And we also, years ago now, we did a training on emotional support animals and service animals. We're happy to do that again. I think it's probably a good time for us to refresh folks on that.
Yeah, that's a very common disability complaint.
Right.
Is
Yeah.
emotional support animals. Okay, so now we're on the reasonable accommodation slide. I think that we were already there. I can't remember. So for reasonable accommodations, the first step is to determine whether or not the property is not exempt from fair housing laws. So if that's like an owner-occupied property of 4 or less units, there's a list of other things that would be in the fair housing training. And you'll want to, determine yourself if there's a connection between the eviction or and the disability. So just because someone has a disability doesn't mean they have the right to request a reasonable accommodation if it's completely irrelevant. So let's say, for example, if the tenant has a disability, which means that they can't work and they receive Social Security disability income, and the cause for eviction is they breached their lease because they were allowing an unauthorized occupant in the house, that's not a connection. So that wouldn't be a reasonable accommodation to request to have the eviction either not filed or dismissed. But a good example and a really common one is if the client is on a fixed income of, for example, Social Security or disability income, and their checks only come on maybe the 7th of the month or the 15th of the month, but their rent is due on the 1st and late on the 5th, then a good reasonable accommodation there would be to have rent due on a specific day. So if they're not getting paid until the 7th, maybe rent's not due until the 15th and late on the 20th. So that's a really common accommodation to request for clients. So if they're getting failure to pay rent cases because their rent is late every month because they're not getting their checks until after the 5th, then you might think, okay, can we figure out a way to avoid these complaints, because the tenant is actually paying their rent, it's just late because they're not getting paid until a certain date every month. Thank you. Okay, so there's one question. Can they charge pet rent for the approved support animal? So I think the first thing you'd want to do is ask them to waive the pet fee, because it's not a pet. So it's really important, especially when you're communicating with the landlord, to just not even identify the emotional support animal as a pet, because the emotional support animal shouldn't be applied to any of the pet rules and regulations. That being said, if the animal can't be, harming other tenants, or, you're not taking care of your animal in the common area. So, it's the reasonable stuff that would have to occur, as obviously would still have to, but you can certainly request that the pet fee be removed because it is not a pet. Yeah.
All right,
Okay.
let's see. What if
So
a
what
lease
is,
is not signed every year? If the resident signed the lease 3 years ago, the rules of the lease still valid? Should a new lease be signed yearly?
so that you'd want to look at the lease, the most
Yeah.
recent lease signed. So the lease would have to include what the renewal clause is. And Maryland requires that the renewal clause be very evident on the lease, and the landlord and the tenant have to initial the renewal clause. So it could be year to year. So if the year lease ends, then it renews for another year. It could be month to month. I guess it could be week to week, or it could also be that the lease is only for 1 year. There is no automatic renewal. Um, and that's really important because typically you only sign one lease at a unit, unless they want to change rules and they want to have a whole new lease. Then typically there's just one lease, and whatever the renewal clause is would take effect. And then so the rules and clauses of that original lease would be what are valid and what you need to look to while that lease is still current. Okay, I'm looking at. Can everyone see the Q&A, or is it just us?
Yeah, everyone should be
Okay.
able to see it. Yeah. I can read it out loud though for folks. What if a tenant breaks the lease early and the landlord puts in the lease that they are required to pay out the remaining amount of the lease? Are they actually required to pay that remaining amount if they have another 5 or 6 months left? Is there a legal maximum amount the tenant's required to pay?
So that kind of depends, and I don't think I can answer the question fully, but the landlord should, if you vacate, then you could potentially be liable for the remaining, if that's what the lease says. But the landlord should also be trying to mitigate damages. So the landlord should be trying to lease the property. Now, this kind of only comes up if the landlord takes you to court for that amount of money. And then that's kind of where you could bring your defense of, the landlord hasn't even posted it on apartments.com. Like, the landlord hasn't done anything. They're banking on me paying this money when they should have actually been mitigating their damages. And that would be important, because if the judge sides with the landlord, well, you vacated early, the landlord didn't get a new tenant until a month later, you should pay that 1 month of rent. So instead of having to owe 5 or 6 months, maybe the tenant only has to pay 1 month. But again, that you technically don't have to make that payment unless the landlord takes you to court for that. And obviously you don't want to get taken to court, so you maybe want to try to negotiate, but technically that could be something in a lease.
So just as a time check-in, we have about 15 minutes left, so I want to make sure we can get through all of the slides. So I know there's 2 questions, but let's just try to move along.
I only have one more slide after this.
Oh, you do? Okay, cool. So we'll just get through this last slide and then we'll answer the 2 questions.
Okay.
Thanks.
So this is the legislative change that I had briefly mentioned regarding rental licensing. So currently, only failure to pay rent cases require a valid rental license to file and to get a judgment. But starting October 1st, 2023, it will require that non-payment of rent, so failure to pay rent, tenant holding over, and breach of lease, the landlord has to have a valid rental license if the local law requires it. I listed out 3 of the exceptions, which are important to note. So the first is that the willful acts of the tenant caused the lack of license. Proving that the local agency's delay or omission caused the lack of license, or that in a multi-unit property, that the license encompasses all of the units in the property or a big chunk of them, are listed under one single license, proving that the unit at issue, so if the tenant lives in that unit, in the eviction, so it's free of threats to the health, safety, in common areas. So those are pretty big exceptions, but essentially all it's saying is that the landlord isn't the cause for the lack of license, but the landlord has the responsibility to prove that the tenant is the cause, or that the agency is a cause, or, something along the lines of, again, the landlord wasn't the cause of the fact that there is no license, and that, they've tried to get a license. So there's a question, is there a public website or place where we can confirm whether or not the landlord has a rental license without going through the landlord? So DHCD should have some of that. I know like DHCD has it for Baltimore City. I honestly don't know if it's statewide. I typically only look for Baltimore City, but you'll first want to look to the local rental licensing law to see if that kind of property falls under a required property to have a license. Because then if you're just searching it and you don't know if they're required to have one, it might not come up. You might think that they don't have one, but you want to verify that it's required. But you'll probably want to look at the DHCD website. If you can't find it there, contact DHCD and see. If you're familiar with any of the like legal aid organizations in your county, they probably know where to find a rental license database, so you can communicate with them and ask. You can always ask the landlord. Yeah, I'm saying DHCD. And also, if you go to court and you say that you don't know, like, I can't verify that there's a rental license, and the property is required to have one, then the property has to demonstrate that they have a rental license. So it's on them to prove that there's a license. It's not on the tenant to prove that there isn't a license. So I hope that answers that question. Okay, so let me go up from the first one. Yes, so if the lease says there is no renewal provision, but the tenant stays and the landlord continues to collect rent, does it default to month to month? Yeah, so if there's no renewal provision on a lease, it automatically defaults month to month. Even if the tenant wasn't paying rent, it would still be month to month. Can an ESA's rule be applied after move-in? If the tenant has a disability but wasn't aware of the ESA laws, is it too late? If pet fees and lease. So you can request a reasonable accommodation at any time. So if the person has an emotional support animal and you're saying they're paying a pet fee?
That's what it sounds like.
Yeah. So I mean, if you've moved in and you didn't know that there was going to be a pet fee, but you have an emotional support animal, then you can make that reasonable accommodation request. So just because you've already moved in doesn't mean that you're barred from making a request for a reasonable accommodation. Okay. Okay. This individual lives in an infested apartment. Landlord has dismissed the infestation and threats to tenant. How do you suggest we go about it? I mean, rent escrow. If the tenant has provided notice to the landlord of the infestation, then if then if the tenant has if they are withholding rent or if they're not withholding rent, they could file a rent escrow defense. If the client is low income, they could potentially fill out a form to waive filing fees with the district court. So that might be helpful. What would happen there is that a inspector would come and check out the infestation and determine whether or not it meets the threshold of a rent escrow case. I would say infestations do. And, you know, my impression from Baltimore City, at least, is that the inspectors are fairly good, the ones that go to court for rent escrow. And so that's like kind of really the only thing I can suggest doing there. There's also 311. You can put in service requests on 311 and have an inspector come out. So if before you want to schedule a rent escrow case, you want to do that, and then maybe that will, get the landlord to start doing something without having to file a case in court and go to court, because it does require the tenant to go to court, which is not always the easiest for everybody. So I answered the website one for rental license. Well, I didn't really answer it, but I tried to point you in the right direction. There is one for Baltimore City. I honestly don't know if it's statewide. So you would just go to Baltimore City's DHCD and you'll go to rental licensing and follow the prompts there and you'll get there. So I'm not familiar with trailer park laws. And that's kind of a beast of its own. And I haven't done that work, so I'm not going to answer that question. I do apologize. But I think the land, a lot of the rules would still apply to the land. So if trailer park owner wants to terminate the lease on the land, then, they have every right to do that, I think. And so that was kind of a really bad situation if your trailer is like not one that's mobile or very difficult to move. That's where there are a lot of issues. But like I said, like that's really its own type of law.
We've encountered these situations before, and yes, that is the case. So we've had situations where somebody's not paying because they're renting the land and they fall behind on those payments. They can then be held liable for having to vacate. It's a tricky situation. I would agree with you. Obviously not ideal for the person, but all right. So let's see. Move on to we answered a lot of questions. This training tends to always bring up a lot of questions. So I've seen a couple of recurring questions regarding providing a copy of the PowerPoint, which I'm happy to do. This is recorded, so everyone, once we've uploaded the training to YouTube, we will go ahead and send out both a copy of the PowerPoint and a link to the recording. In addition to that, I've seen more than a few questions on emotional support animals and service animals, which indicates to me that we need to offer another training on that, which I'll work on getting scheduled. So that's something that I can put together. But does anyone have any final questions before we wrap up? And thanks, Kane. You were very good with your timing on this. It was a great job.
It's longer than I thought. So.
Yeah. All right. Well, I appreciate everyone's time and participation. Hope you have a good rest of your day and a great 4th of July weekend. And Yeah, so look out for my email. I'll make sure that everyone who has attended today gets a copy of this great information. And thanks, Kane. Appreciate your time.
Have a good weekend, everyone.
All right, take care, everybody.